Reassessing South Africa's Land Restitution Program, a legacy of failures and a call for reform. 30 years post-apartheid, South Africa continues to grapple with the complexities of land restitution, a vital aspect of the country's transformative agenda aimed at rectifying historical injustices. However, as the situation in Keiskammahoek's Lower Zingcuka community illustrates, the program is plagued by inefficacy and corruption, necessitating a significant overhaul. The Lower Zingcuka community's distressing story sheds light on broader systemic issues undermining the land restitution process. Having lodged their claim within the designated time frame by December 1998, the community remains entangled in bureaucratic delays over 2 decades later. The promise of justice for those dispossessed by the apartheid regime, heralded by the Restitution of Land Rights Act of 1994, appears unfulfilled, with numerous similar communities across South Africa sharing in this prolonged struggle. Successive government officials, including ministers and members of the Land Claims Commission, have repeatedly acknowledged that the claims were ready for settlement, yet no substantial progress ensued. Recent promises in Parliament by Minister Madonsela Naihanso also proved empty, further eroding trust in the system. This bureaucratic inertia is symptomatic of a broader malaise characterized by a lack of political will, incompetence, and possibly fraud within the institutions tasked with executing land restitution. The Lower Zingcuka episode, where fraudulent claims were purportedly tabled by a non-existent chief, underscores the systemic manipulation and potential corruption plaguing the process. Additionally, despite substantial funding allocation, about R50 billion spent on the program, there's a prevalent push towards financial compensation rather than actual land restoration. Instances like the Moloteli land claim demonstrate the state's inclination to negotiate settlements that favor financial payouts over returning land, often against the community's wishes. The legislative framework itself, with roots in the interim constitution of 1993 and later embedded in the final constitution, was designed to address dispossession post-1913 due to racially discriminatory laws. However, this cutoff date excludes numerous grievances stemming from earlier colonial dispossessions, thereby limiting the scope of justice served by the program. The program's current trajectory suggests a dire need for reevaluation and restructuring. South Africa must address the fundamental flaws in its approach to land restitution that not only hinder progress but perpetuate the socioeconomic disparities that the program initially sought to mend. An effective land restitution program should not just compensate financially, but must prioritize the actual return of land, ensuring the restoration of dignity and rights to indigenous and dispossessed communities. This reflection posits that without a robust reconsideration and significant reform of the land restitution framework, South Africa may continue to witness the erosion of public trust in its institutions and the perpetuation of inequality, outcomes starkly at odds with the transformative goals envisioned at the dawn of its democracy. Moving forward, South Africa's focus should pivot towards a more inclusive and aggressive land redistribution strategy, emphasizing equitable land access and utilization to truly empower the dispossessed natives. As the nation continues to confront its past, the imperative for a redefined land reform strategy becomes ever more critical to achieving true justice and equality. Thank you for choosing Satori News.